Surana firm. Various academic people present here. Law students also present here. Ladies and gentlemen, my association with Surana and Surana is about 15-16 years old. When I went as a chief guest in one of the Moot court competitions at ILI Pune, where I was the Additional Solicitor General of India in 2006. Mooting, I have found, is a very important way of giving practical experience to budding lawyers before they actually enter into the profession. But before I dwell more on mooting, I must tell you what our experience was, or rather my experience was as a lawyer, because in our time there was no moot. In our time, I passed out in 1983 from Campus Law Center, and out of the 3 years of my legal course, I could not attend classes for a very long period of time because I also had a job. I worked for 9 years in Steel Authority. I was marketing steel for 9 years, nothing to do with law. Joined as a lawyer in the year 1990. And before actually resigning, I came to Supreme Court and I thought, let me just see whether I can fit into this profession or not, whether I've been too far away for a very long time to be able to come back to this profession, because I was doing nothing to do with law. I was only selling steel. So I took a 6 months break. I had enough leave available with me. I took a 6 month break, came here during my leave, tried to do a lot of research. I really enjoyed that work. I remember the Kashi Vishwanath temple takeover was being handled by the person with whom I came to join, Mr. L.R. Singh, my first senior. And there was a vacation where I went to Patna, to my village, and I carried all the books, all the judgments on Article 25-26, which were dealing with fundamental rights to religious institutions. Each judgment was maybe 200, 300 pages, all constitution bench judgments. So I came back with the entire volume of research and I told my senior, and then he used to take me to the briefings. I was not a lawyer then, but he gave me the upper hand in the briefing because he said the kind of research he has done, so let him brief the senior. Mr. P.P. Rao was the senior whom used to brief. I got a lot of confidence that I can probably get into this profession, so I finally resigned a couple of months later. And it was sometime in June that I got registered in 1990 in Patna, and I came straight away to Supreme Court to start practice. The courts were to reopen after recess, I think first week of July, some date, I don't remember the exact date, maybe 5th or 6th July of that year. So I told my senior that as a child I tried elocution once in the 4th or the 5th standard, and I remember my legs were shaking. So now that I've already resigned, what do I do? I mean, will I be able to practice? Will I be able to argue? Will I be able to stand up and address a court? So I think probably the harshest way to teach was taken by my senior. On the very first day of the opening of the Supreme Court, he gave me 3 briefs to argue. First day of my career as a lawyer, first day in court, and he gave me 3 briefs to argue. And I remember the first case I argued, it was before Justice Venkat Chaleya. So I was, since in our organization working, I was calling him sir. I kept on arguing, sir, whatever I had to say, I kept on saying. He did not agree with me. He also said, sorry sir, and left the fight. So I said, sir, I have to say something else. I have to say something more. He said, I'm so sorry, sir. He picked up the file again. He heard me very patiently. Then again, after 5-7 minutes, he said, sorry, sir. And then he dismissed the matter. My senior was standing at the back He said, why were you calling him sir? This is not done in our profession. I said, I actually, this is my first day. So I still had not got to the concept of calling my lords, etc. But that is the kind of mooting I got, the experience of mooting I got as a lawyer straight away in court. But I feel that this is a great way to, at least I could have not been able to speak at all. I was lucky, I would say God's blessings were with me, that I did not falter, my legs did not shake. I could continue with my argument. I argued the next matter and the third matter also, all three I argued that day. But there could be a situation where somebody could have, really sort of broken down. And that is a great opportunity that today's law students get in this moot court competition. It's one way for you to realize how good you are on your legs, because I was hearing the other panel discussion a little while ago where Professor Bandyopadhyay said that it should be always the choice of a student to decide whether he would want to go into the legal profession as a lawyer or whether he would like to join a law firm. But I have a small rider to that. And the rider is that every law institution should try and find out during the curriculum of how good is a person on his feet or whether he is better on his seat. Because the difference between litigation and working in a law firm is that in litigation you have to take every call on your feet. There is nobody to tell you when you are going wrong. If you go wrong, your client goes for a 6, and there is no way you can retrieve unless if there is if you are in the Supreme Court, obviously there is nobody else. It's only God. If you are in a lower court, then at least you have a right to go and appeal. But even in appeal, if you have not argued something, the appeal court will say, well, you didn't argue it before that, then why should we interfere with the order if you didn't argue it that way? So that's a huge call which you have to take as a law student. And I would say that a student, before deciding whether he would like to get into litigation or whether he would like to get into a law firm, there are a lot of people who can calmly think and come up with a beautiful opinion where they have the opportunity to look at all the research papers and see everything and come up with something very, very brilliant. Those people may not succeed as a lawyer. They may not be able to speak up. They may not be able to deliver as a lawyer, because a lawyer, I would rather also compare litigation versus law firm work would be like something, you want to be an entrepreneur, you become a litigator because you really are managing everything yourselves. Your time management has to be a huge factor in your day-to-day life. You have to manage time for your family, for your friends, for the research work, for the drafting, and for the argument, and all this has to come in sync. Your research can't go on beyond when the hearing is to take place. Your research has to be prior to the hearing. So your drafting research also has to take place before the matter goes into court for filing. So these timelines are so important in litigation that that really calls for an entrepreneur in many sense. To be able to sell yourself to a client. Ultimately, it's not that you should know law and you should be able to deliver. You should be able to sell yourself to the client also. And my most important and humble advice to all budding young lawyers is that the best way to sell yourself to the client is to be honest. And when I say honest, I mean two things. Firstly, that when you talk to a client, you have to tell him how good or bad his case is, whether the client likes it or not, whether the client continues with you or not. You have to tell him what according to you is right for him. I have done so many cases in Supreme Court where I have told people that there is no point of spending money coming to Supreme Court, and a person who has come from the High Court, he is not satisfied, he goes to some other lawyer and he says, no, you got a fantastic case, and then he goes and gets it dismissed. Then that client remembers that lawyer had refused his fees and told me not to litigate. So that's where your value comes in. And second is that when you are, the client will be very moneyed, but if you look at his pocket and not his problem, then there is a problem. You have to look at his problem. You have to solve his problem. You have to take his problem as your own, and then only, because unfortunately in India, there is no way you can advertise for yourself. Your growth in the profession is all word of mouth. And I can tell you, there are a lot of youngsters here. I can see probably some law students also. I'm sure this is also partnered by these institutions. So this I can say with a lot of seriousness that in today, juniors who are coming to the legal profession, I find very few who are ready to work for getting relief for the client. They are more interested in money, and that's where they go wrong. This is one profession where money follows you. I am a first generation lawyer. There was nobody in my family who was a lawyer. I had no backing, no judge, no senior advocate, nothing. And I can tell you, assure you, that without any backing, without any support, I have come wherever I've come. Of course, God's blessing I can never forget. But I remember when I was the additional Solicitor General, I don't know whether some of you may be aware or may not be aware, there was a huge issue of when the forest advisory case was going on, and the the Environment Secretary then he told me that the Supreme Court is wanting to thrust its members on the committee, and I don't want that to happen. I have my own list of people. Why should be? So I said, if you are ready to take a stand, I am ready to take a stand. He said, yes, I am ready to take a stand. So it was Justice Sabharwal's bench and 3-judge bench of Supreme Court. I said, you can't tell me whom to make as a member of the Forest Advisory Committee. It's an executive function, the government has to decide. Justice Sabharwal's reaction was that so many Solicitor Generals, because that was the T.N. Godavarman matter, and it was going on for last almost more than 10 years by then. So many Solicitor Generals and Attorney Generals have come, and nobody has told us that we don't have the right. I said, they may not have told you, but that's the law. And you have to hear me before you decide that your name should be put. And they had to ultimately agree, and the government put its own names. Because it's an executive function. There is a concept of separation of powers. This case was on the headlines of every paper of the country, where it was put as if the government, asserts its rights in Supreme Court for the first time. A judge of the Supreme Court, sitting judge of the Supreme Court, told me that as an additional Solicitor General, you are taking too much of panga with judges. Of course, in a private party. He says, when you debit office, you don't know these judges. It's a huge trade union. They'll say that they will ensure that you lose your practice. I said, I've come here without any support of a judge. So I don't intend to continue with the support of any judge. And that is, touch wood, nothing I will call it touch wood. So I will expect, it has been a long day. I don't want to take too much of time today, but I would only say that Surana and Surana, for 25, Surana probably 25 years, I would say, means that probably it was almost the start of mooting in this country. There was hardly any mooting happening. Especially there was hardly any institutional mooting of this kind of nature, where a law firm was involved in organizing moot courts. Because once a law firm comes in, and especially a large law firm with such a big establishment, I'm told you're now all over India now. So when a large law firm takes up this assignment and goes to these institutions and tries to organize moot court, I'm sure it becomes a far more, I would say, organized activity, and it brings in so much of more visibility to the students when they join in these moot courts. So it's a great service that you people are doing, and 3 cheers to you. We must all clap for the great work that Surana and Surana have been doing all these years. And I would really like to wish all of you great times ahead, and I also wish that Surana and Surana is able to do more and more of this kind of activity, so that the children of today get a first-hand exposure of how to stand on their feet and think, and without their legs shaking. Thank you.